Good morning. This is Tuesday, March 30th, and is a meeting of the Virginia Redistricting Commission. I am Greta Harris, co-chair of the commission, who will be presiding over this meeting. On behalf of my co-chair, Mackenzie Babachenko, we wanted to welcome you to this meeting. We are excited to be working in partnership with all members as well as citizens of the Commonwealth of Virginia to ensure a fair and just election system. We are hopeful at the end of our work together that we will be an exemplar for the rest of the world on how we can do this work together. We wanted to express appreciation to the Division of Legislative Services staff, especially Amigo Wade and Claire Waters, for all of their assistance over the last few months in helping us to get organized, set up the website, set up emails, get our communication rhythm in place, and we are ready to do the work on behalf of the citizens of Virginia. I wanted to remind members, staff, and other speakers on today's virtual meeting of a couple of things. First, please keep your microphones muted until you're ready to speak. This improves the quality of the audio for the meeting. And before you speak, please remember to unmute yourself. If you forget, that's okay. We'll remind you. We've all been there. And also, please remember to state your name before speaking, and especially before making a motion. This helps in keeping track of what is happening throughout the meeting. Any votes that we take today will be done by voice and by giving a hand signal, and staff will call the roll call for each vote taken. We do have a full agenda with some analysis and feedback that we want to hear from you on our timeline or proposed timeline for this year. We have a training session on Foia, and we would like to try to have those two things, if possible, wrapped up by 11:30, because we have 18 citizens who have registered correctly to be able to speak during our public comment section of the agenda. Because of the number of folks that we have, we are looking to limit to 2 minutes comments that citizens will be making. And to members of the public who wish to comment on the agenda, they may also do this by sending an email to VAREDIST at dls.virginia.gov. The comment will be posted on the division's website, which is located at redistricting.dls.virginia.gov. And for members of the public who would like to comment on anything in general, you can send to that email again, VAREDIST at dls.virginia.gov. Right now, to ensure that we have a quorum, we're going to ask the staff to do a roll call of commission members, and we'll do that, and then we'll come back and look for a motion to accept the agenda for today. So I don't know if it is Claire or Amigo who's going to call the roll of commission members.
Madam Chair, I'm going to do it for this meeting.
Thank you, Amigo.
All right. Mr. Abranio?
Present.
Mr. Feliciano? I think he was.
I'm here.
Okay. Mr. Gilliam?
Yes, here.
Mr. Harrell?
Here.
Mr. Hutchins?
Here.
Mr. Kumar?
Here.
Delegate Adams?
Here.
Senator Barker?
Here.
Senator Locke? Senator McDougal?
Oh, that's my man.
Locke is here and McDougal's here too.
Senator Delegate McQuinn?
Here.
Senator Newman? And Madam Chair, I've just got an email from Senator Newman. He is trying to get into the Zoom call, so he will be on.
Okay.
Delegate Ranson?
Here.
Delegate Simon,
Here.
Ms. Pachinko,
Here.
and Madam Chair.
Here.
You have a quorum, Madam Chair.
Thank you very much. So hopefully everyone has received the agenda and has also received all of the attachments for the draft proposed timeline. At this point, we are looking to, the agenda includes having discussions and refinements on the proposed timeline for our work in 2021. We have training on the Freedom of Information Act, and then hopefully by 11:30, we will start our public comment period. If people are, members are okay with the proposed agenda, we would, the chair would accept a motion to approve the agenda at this point.
Madam Chair, this is Rick Harrell. I move we approve the agenda.
Okay. Anyone for a second?
Chair, this is Mackenzie Babachenko. I move for a second.
Thank you. And again, we ask that people please keep their devices on mute while we're having the meeting if you aren't speaking. Thank you. And Amigo, could you please call the vote on acceptance of the agenda, please?
Madam Chair, I think that you can do that with a voice vote.
Okay, all right, thank you. All of those in favor of accepting the agenda signify by saying aye. Any opposed? Any abstention? Okay, the agenda stands. Thank you very much. And with that, I will turn over to Amigo Wade to walk us through the proposed timeline of the commission for 2021.
Thank you, Madam Chair. And just by way of explanation, what this document is, please don't think that it's something that you have to accept whole cloth. What staff tried to do in working with the co-chairs was to sort of give you a roadmap over which you would have a framework to work from to get the work of the commission done over the course of this year. We've broken down into 6 phases, beginning with preparation and ending with post-plan submittal. Now, one of the things that we are suggesting is a meeting cadence of every other week, at least for the initial several meetings. And based on the polling that we did for this meeting, it appears that Tuesday is, I know this is going to be a technical term, kind of, sort of the best day when you have 16 very busy people. But that's what this lays out, basically, with a meeting cadence of every other week, Tuesday meetings. And we have actually proposed scheduled meetings out to May 11th. One of the things that has been a concern that has been expressed to us by the public is being able to see a meeting schedule so that they can be prepared to participate. Just walking you through the phases. The first phase, which has a March through April general time frame, the general goals there are to develop processes and really preparatory training. We have 2 meetings suggested, with this one being today, focusing on Foia, and the next meeting focusing on meeting etiquette and things of that nature. You also see that there are several decision points, administrative decision points. We're not asking that we do those today, and we can certainly work with the co-chairs to come up with some suggested responses for those decision points that we could possibly take up at the next meeting, and which would move us to the to phase 2, which we're titling the education and training phase. With that, we're looking at education and training, but getting more specific to your role in terms of the redistricting and reapportionment, with the focus on getting you all familiar with your roles and responsibilities. And one of the things that is helpful with this additional time that we have is can spend some time on basic training and role familiarity. We are suggesting 3 to 4 meetings there, and again with that with that every other week cadence. On the April 27th, we would have a meeting focused on basically redistricting 101, where you get into some of the mechanics of it. Legislative services staff will present there, as well as we're looking at having a representative from the Census Bureau to have a presentation also. On the 11th, we're looking at a meeting, the 11th of May, a meeting that would really get into the mechanics of redistricting. And one of the things that we're looking at there is a presentation from the software application provider. That would move us to phase 3, which has basically a June, and understand these phases will blend into each other, and certainly possibly have additional meetings or to have the meeting cadence to fit whatever works for the commission members. Phase 3 will focus on more specific commission planning. The 3 basic goals there: first, to schedule the first round of public hearings. Based on our reading of the statutes, you have to have 3 public hearings before proposing plans, and 3 meetings before voting on the plan. I'm sorry, 3 public hearings. Also establish a work plan for the actual map drawing, and to develop some public participation guidelines for map drawing as well as for the public hearings. We would then go to phase 4, which is where we will get into the practical preparation aspects of your jobs, as well as focusing more on public outreach. That's where we will conduct the first round of hearings, and we are suggesting the possibility for some hands-on training for individual commission members. I guess we were calling them sort of map drawing labs, where small groups of members can either come into the office, or we'll try to set up something virtually where you can practice on, drawing maps. Phase 5, which we're calling the receipt of census data and map drawing. I think that one of the reasons that we sent out the revised draft is the Census Bureau put out a communication a couple of weeks ago. As you know, the last communication before that one had a September 30th general date for delivery of the census data. That their communication indicates that the second week of August, they will be able to provide census data. It won't be formatted the way it's normally formatted, but it is still census data. And we've talked with our software application provider, and they will be able to work with that information. But the 2 goals for that phase are to receive the census data, and by statute we have to include in that data prison population reallocation, where basically we've received information from the state and local prisons in the state, and the goal there is to if you have a prisoner that's in Red Onion, we try to find out where that prisoner is, where his or her residence is, and then that would be added to the census data.
Chair? Mr. Delegate Simon, can I interrupt and ask a quick question while we're on this topic of the data?
Yes.
Uh-oh. Madam Chair is still muted. I was waiting for her.
No, go ahead, please, Delegate Simon.
Thank you. So, and again, I apologize. I know you had a flow, but I think now is probably time to ask. One of the things I'd read about the data that's going to be sent down in August, as you mentioned, it's not formatted the way we would expect it to be. But you said you've spoken with our software provider. I just want to make sure that yes, we can work with it, but are there any potential downsides to accepting the data in this format? Again, I read some places, and you guys know better than I do. I'm not prejudging the answer. I just think it's probably worth getting it on the record. Are there any downsides as far as taking the data in this format early versus waiting another 4 to 6 weeks to get it better? Not better, but in the up-to-date.
Yeah, I see that Meg is on the line. I think she's in a better position to answer that. Meg, if you could take care of that.
Right. So the Census Bureau's announcement was that the data was going to be in the legacy format, which made everyone a little hesitant. Like, what does that mean? And in our conversations with our software application provider, who had a conversation with the Census Bureau, what we now know is that legacy format means we're getting the data in the same format that we've received in previous cycles. So it is in the format that our provider is used to working with. It'll fit in the database that has been built already. What's coming in September on September 30th is going to be a more user-friendly. It's broken down into tables. And so in a state where maybe they don't have the contract or relationship with their software provider that we have, they would be able to more easily manipulate the data to fit their purposes. But we'll be good to go. He does not anticipate any issues with putting it in the database or making the adjustments for the prison population reallocation.
Meg,
Thank
can I?
Thank you, Mr. Wade and Meg.
Okay, Meg, can I also ask that when does the clock start ticking on our body of work? Is it after the adjustments with the prison population, or is it as soon as we receive it, then the clock is ticking?
Madam Chair, so the clock will start 45 days from receipt of, well, the clock will start when we receive census data. So we'll need to have those maps to the General Assembly within 45 days. The law does build in about 30 days for the reallocation adjustment, and that chews into the 45-day chunk. But when we talked to our software provider, he indicated that he does not anticipate it taking nearly that long to get it all adjusted. We've done most of the prep work, or he has done most of the prep work. So we should be ready to roll by the end of the beginning of September, and would have probably that month to do our work.
And thank you very much, Meg. And I apologize that I did not introduce you as part of the DLS.
I was hiding.
Team.
Don't worry.
Meg Lamb, who's going to be a critical, partner with us as we do our work later on this year. Thank you, Amigo. Sorry. Okay, James. Yes.
Just to follow up on that, Ms. Lamb, it seems to me that if we get the data in the legacy format, that then triggers the 45 days. Is there, we're coming to this as citizens. We've never seen even the legacy format. I wonder, is there any harm in waiting until it's in the most user-friendly format, or will it not matter since we have that relationship with our map people?
Madam Chair, Mr. Bernio, so for your purposes, it won't matter. We will have, our vendor is going to take that data and put it into the database in the format that you all will need to use it. And I think for all intents and purposes, this is that census data that's going to trigger it. I think it would be risky for us to say, oh, we're going to consider the September 30th, the actual census data. And that's when our clock will start to run. I think there might be a challenge there.
James, did you get your answer that you needed?
I think I did, so long as our proposed schedule, we're going into July, August, and then September, October. I just want to make sure that, and it sounds like you guys are considering that we're not extending our proposed schedule, but then we're going to be getting the data early and how that crunches time.
Right. So we revised the timeline that we had created to reflect the mid-August receipt of data.
Great, thank you.
And I think,
Madam Chair, this is Rick Carroll. I've got a question for Meg.
Yes, sir.
You said it would be concerning or somewhat problematical to put off the beginning date till September 30th. What's the concerning part?
So I think the constitutional amendment does say that these maps have to be submitted to the General Assembly within 45 days of receipt of census data. The point I was trying to make was that data that we will be receiving mid-August is census data. And if we tried to say, hey, actually, we're going to say that the census data that triggers this is the stuff we'll receive in the end of September, I'm not sure that we can make that argument when the data that we're receiving in mid-August is census data. We had expected to only have one, deadline or one receipt of data, but it turns out we'll be having two. But I think the first one will be what needs to trigger the time.
Okay, thank you.
Madam Chair, I believe that Senator has a question.
Yep, Senator Barker.
Thank you, Madam Chair. Do we have already the information on the prison reallocation, so we know what, as of April 1st of 2020, where the prisoners were that are included in this calculation, and where how many would be reallocated to which jurisdictions and which areas?
Madam Chair, Senator Barker. So yes, last summer we worked with the state and local correctional facilities to receive essentially their head count as of April 1st, 2020, and the information required to do the reallocation. That has all been provided to our software provider, and he has gone ahead and done whatever geocoding he does to get that ready. So once we do receive the population data, he says it should take about a week to move everyone around.
All right, thank you. That's good.
Other questions that members have on the proposed timeline? I saw in the chat that Senator Locke has a conflict with Tuesday morning meetings. And I don't know, Amigo, whether or not we did some polling, and it's almost like trying to thread a needle in a snowstorm, trying to get dates that work for everyone. But Senator Locke, this would be an ongoing conflict with you, right, on the proposed Tuesday morning?
Just through the end of the academic school year, which ends mid-May.
Okay, thank you for that information. And maybe Claire and Amigo, we can go back and look at the options that we have. And I think that's Tuesday and Thursday mornings, right, Senator Locke?
Correct.
Okay, through mid-May. Okay. We acknowledge everyone's busy schedules, and we were trying to look out ahead and just so that we could try to block off our calendars as much as we can to try to have the greatest participation in the process. So we'll go back and maybe propose some alternative times and days to try to get as many people participating as we possibly can.
Madam Chair, I would suggest that, since we have everyone on, would moving that day up to Wednesday, would that be a better fit for everyone?
Basically saying no more Uncle Tom. Now we're new Negroes. So the new Negro was a revolution against Uncle Tom, but it was Garvey in
Senator Locke, can you possibly maybe mute? I think we're hearing some feedback. Thank you.
Yeah, you're hearing my movie I'm showing the class.
Okay. I hope it's a good one. All right. How do people feel Wednesday mornings from 10 to noon?
Madam Chair.
Yes.
This is Senator Newman. Good morning. Sorry I wasn't here earlier, ma'am. I wonder if maybe they could do some just polling offline. Some of them, like I imagine yours and others, are very complex. But if maybe they endeavored to do it offline, that may very well work. But it'd be great to kind of be able to take a deep dive into the calendars, if that makes sense to you, Madam Chair.
Thank you, Senator Newman. Amigo, is that possible that we can do that through a doodle or some other outreach? But we're going to ask members of the commission to be as responsive as you can, because we're trying to line up the various trainings and schedules. So when we reach out to you, please respond as expeditiously as you possibly can. We would appreciate that.
Madam Chair.
Yes, Claire.
This is Claire Waters. I can send out the poll this afternoon to everyone's redistricting email with just a Monday through Friday timeline. And if you can please choose the date that works best with your schedule, and then we will keep the 10 to 12 time if that works for everyone.
Okay, fantastic. All right, Amigo, is there more that you want to walk through just when we celebrate, when everything is done, after the map drawing, and I believe that we have more public hearings afterwards?
Correct, and then which takes us to the last phase, which is basically post-plan submittal, where the commission would be monitoring General Assembly action. If you look at the statute, that it may come back for more map drawing. So, but that would be the last stage. And that's basically, what we are trying to provide here is a basic roadmap to cover things from this point through the end of finishing y'all's task. And that's basically all we have, just in terms of to offer for the timeline.
Thank you so much for that. It's going to be a busy year, but I think everyone will appreciate having the year mapped out as best we can. Are there other questions that commission members have regarding the proposed timeline?
Madam Chair, this is Joe Feliciano. Can I make a suggestion?
Yes, sir. Hi, Joe.
Can I suggest, seeing that we're talking summer, spring, we have graduations, we have summer, people are going to be traveling. May I recommend that people, if they are planning to travel or whatever, say, hey, from this date to this date on this week, I will be wherever, or I'm not available for whatever reason. That could make planning a little easier.
I think if people know there are definite times of the year, and I compliment folks that are that organized, that know that far out, whether or not they're going to be available or not, but that would be great too. And I think there is an acknowledgement that we won't have 100% of commissioners for every meeting, but as long as we have an adequate quorum, we will carry the work forward on behalf of the entire commission. So any other questions that folks have?
Madam Chair, the only recommendation I have as far as the polling, just put a deadline. Hey, you've got to respond within 24 hours, because I think there was probably some lag, and then all of a sudden scheduling goes over. Thank you.
Great suggestion, James. Thank you so much.
Madam Chair.
Yes. Yes,
briefly,
sir.
I'm not sure if I fully understand not Mr. Benio's comment, but the comment before it. If I heard it correctly, it might have been on, not all of us saying when we plan to be gone, but if we assume that we're going to be getting the data in August, even though it is out into the summer and fall, I know people with either kids in school schedules, or I know I've got some work and possible trips out of town post-vaccination plan. If I had an idea now of, hey, protect this week, that week, or whatever, I'm more than happy to do so. But I'm going to be making decisions even in the coming weeks that will go out into July, August, September. And if we had designated blocks then of what we should all try to protect, we may boost our opportunity to have more attendance.
Thank you, Sean. Mackenzie and I have talked with the DLS staff previously around once the data is received. That's where the most intensive time commitments are going to be required of the commission. I'm sorry about my kitty cat. And so I think in the upcoming weeks, Mackenzie and I will work with, Amigo and team to really look at when we think we will receive the data from the census, and then try to block out appropriate amounts of time. And it may be whole days or several, clusters of days for getting that body of work done. And I think if you can just afford us a little bit more time, I would say sometime in April, we might be able to propose those blocks so that people can mark it on their calendar, if that can work. Okay, thank you very much. All right, unless there are any other pressing questions on the proposed timeline, and I guess there's one more statement in the chat saying, will Foia training address the use of the chat feature? Hopefully so. Maybe they will. And we will try to figure that out when our guest presenter will get started on the Foia training. So with that, I think, Amigo, we have our marching orders for refinement on the proposed timeline. We're going to poll people one more time to try to get the best days for the majority of people to participate from 10 to noon every other week. Okay, so just look out for Claire's email later on today. And with that, I think we'll invite Mr. Alan Gernhardt, the Executive Director of the Freedom of Information Advisory Council, to come forward and do our formal training on FOIA.
Thank you, Madam Chair. Can you all hear me okay? All right. I'm going to go ahead and share my screen. I do have a PowerPoint, or actually, I'm not able to share my screen. It says host disabled. Well, there is a PowerPoint.
Okay, hold on one second. I'm sure Claire is working her magic here to give you co-hosting powers.
Day is working her magic here.
Thanks, Claire.
And Mr. Gernhardt, I'm sure everyone is sitting on the edge of their seat and,
yes.
and hardly contain their excitement around hearing what you're going to share. And I know our legislative colleagues know FOIA very well, or those of us who work on various public bodies.
Yes.
But for those who haven't experienced that, it is there's lots of important information I'm sure that Mr. Gernhardt will share with the commission.
Thank you, Madam Chair. And let's see. Yes, now I can share it. So just a quick introduction here. Make sure everybody can see. Let's see. This is not. Get to the proper page. Okay. Now, there we go. Can everybody see that on the screen? Or I guess I'll ask Madam Chair. Can you see it?
I can. Thank you.
Okay, excellent. Then I'm assuming everyone else can, because I cannot see the chat while I've got this going. So first, just a little bit, I am also legislative services attorney. I've been with legislative services since 2004. So I'm part of DLS as well. And as we're talking about FOIA and the FOIA Council, I will mention that, of course, you have Senator Locke here and Delegate Simon, who are chair and vice chair of the FOIA Council currently, just so you all are aware of that. This first slide is probably the most important and most valuable information I can give you today. It's got our website, our email address, and our phone number. And we have maybe 45 minutes to an hour maximum to cover FOIA. FOIA printed out single-spaced is about a 60-page law. So even if we could do a page of legalese a minute, we'd barely get through it. We're just not going to have the time to go into a whole lot of detail. So I want to remind everybody, if you have FOIA questions, you can always contact us. You're welcome to do so. This is a big part of what we do, is just answer questions from government folks, from citizens, from media every day. So feel free to reach out anytime. A little bit of a roadmap as to where we're going with the training today. We're going to start with an introduction, talk a little bit about the FOIA Council's work, as well as FOIA itself on policy and kind of overarching ideas. Then we're going to get into a little bit of the nuts and bolts for public records, public meetings, and the remedies and penalties part of FOIA. Roughly, just so you know, we're talking about roughly 5 slides for the introduction, roughly 5 slides on penalties, about 10 slides on records, and about 20 slides on meetings. We're going to go a little more heavily into that. Some of this stuff I will be glossing over. It can get very detailed and very nuanced. And again, we just don't have the time to get into that much detail. To start with the introduction, we're going to talk about the FOIA Council and the purpose of policy of FOIA. But first, just a little bit of the structure of FOIA. And so you all are aware, if you have this PowerPoint, all of the things that look like hyperlinks are hyperlinks. These will take you to the relevant code sections. So if you ever want to look through and try to find something yourself, you can do so. FOIA is not actually formally broken into articles, but it is kind of sectioned off into the general provisions that start the act, the records procedures, then meetings procedures, and the remedies and penalties. I would note FOIA does have training requirements in with the records procedures. 2.23704.2 and 2.23704.3 are specific training requirements for FOIA officers and for local elected officials, respectively. As state elected officials and state level appointed officials, you do not actually have specific FOIA training requirements. So you don't have to worry about that directly. A little bit about the work of the council. You'll see that's our enabling statute at the top there, 3178 through 181. We are a state legislative branch advisory council. We have a total of 4 legislative members and 10 citizens who represent different areas, state employees, local government, media, and others. Appointments are made by Senate rules, by the Speaker of the House, and by the governor. So we have a fairly broad representation on the council. The council itself serves as a legislative forum for various studies and recommendations to the General Assembly. Staff through DLS, we generally answer the questions on a day-to-day basis from government, citizens, media, and we generally draft the advisory opinions and educational materials that you can find on the website. We also do these FOIA training presentations. A little bit about what we are not. We are not an investigative or enforcement agency. People sometimes call me up and say, I want to file a FOIA complaint. That's not what I do. I'm here to help educate people on what FOIA requires, and I do try to help people informally work out FOIA conflicts and problems. But if someone wants to enforce FOIA, enforcement's through the court system. A little bit about the purpose and policy, because FOIA is one of the few laws that actually has a full policy statement in the beginning. It says, and I'm going to actually read part of this. By enacting this chapter, the General Assembly ensures the people of the Commonwealth ready access to public records in the custody of a public body or its officers and employees, and free entry to meetings of public bodies wherein the business of the people is being conducted. The affairs of government are not intended to be conducted in an atmosphere of secrecy, since at all times the public is to be the beneficiary of any action taken at any level of government. Now, I know those of you who already serve on public bodies are familiar with the concept, but for those who haven't served, if anybody has never been on a public body before, this is where I talk about, elementary school civics class and things like of the people, by the people, and for the people, which everybody's heard these, and they're kind of a cliche to most of us at this point, but that's what we're doing right now. We are citizens serving in government. And it's important to keep in mind, whether you're an elected official or an appointed official, you are a government official. And when you're doing official government work, public business, the public has a right to know what you're doing as far as the meetings and public records. And that's something that conceptually over the years, I've trained a lot of different groups, and some people are saying, well, but I'm just a citizen appointed to the board. I'm not really a government person. Well, you are now, as soon as you get appointed. So keep that in mind. Whenever you're doing your government work for the commission, it is public business. FOIA goes on to have some rules of construction. It says that everything in FOIA is to be liberally construed to promote the awareness of government activities and operations, except for the exemptions. Any exemption that allows you to withhold a record or close a meeting to the public is to be narrowly construed, meaning they don't stretch. And I usually call that the Johnny Cochran moment from the people who remember the O.J. Simpson trial. If the glove don't fit, you must acquit. Well, for FOIA purposes, we say, when in doubt, give it out. So if you keep that in mind, if you're not sure about an exemption sometime, do it in public, whether it's a record, you have to release it, or a meeting, and you do it openly. Last, we also reiterate in here, no record shall be withheld or meeting closed to the public unless it is specifically made exempt. So the default rule is always that public records, so anything you do that is commission business and public meetings, when you're actually getting together to discuss it, is going to be public. That is your default unless there is a specific exemption. I also keep in mind, and this is for other trainings as well, there are other laws out there besides FOIA that can affect public access. Depends on type of record, type of meeting, type of official. And because our authority is limited to FOIA, there are times when I have to tell people to refer out to other laws. For example, I do know, and I'll just read part of this, in 30-392, some of the enabling legislation for the commission. I'm just looking at the first sentence of subsection F. All meetings or records of the commission shall be subject to the Virginia Freedom of Information Act, except as provided in a different section. So things like that, it's outside of FOIA. I can refer it to you. I may or may not be able to give you an actual interpretation of that if that's required. Turning to public records, a little bit of the nuts and bolts. The important part of this is that everybody knows how to recognize a FOIA request and be able to respond to it within the time limit. A lot of the time, you're probably going to have staff helping you out with this stuff, but it's important to know, if you get a FOIA request, you need to get that to staff because there is a time limit. So we start with, again, the basic policy that all public records are presumed to be open unless they're specifically made exempt. With the definition of public record, I break this down. The first 3 bullet points are actually quoting the statute. We talk about all types of records in the first bullet point. It's however stored regardless of physical form or characteristics. Keep in mind, this means handwritten notes. This means email. This can be text messages. This could be a Facebook post. This can be fax messages. It could be something that's an audio recording. It could be a video recording. We don't really care about the type of record. Also, because it says however stored regardless of physical form or characteristics, we don't care what device is used to create or store the record, and we don't care whose account it is even. So for example, if any of you decide to use a personal email account to conduct commission business, that would still be public record. Doesn't matter if you use your home computer, if you have a government issued laptop, if it's a personal account, if it's a .gov account, none of that really matters for FOIA purposes. What we're really concerned with is the next 2 bullet points. Is it something that was prepared or owned by or in the possession of the public body, its officers, employees, or agents? And is it in the transaction of public business? With that second bullet point there on the prepared or owned by and the possession of, generally prepared is the easiest one. It means you made it. You know if you prepared it or not from the start. Owned by generally is equally obvious, but not quite always. Sometimes, and I don't know if this commission will do it, but you might hire somebody to do some work for you, or hire a consultant on something, a contractor to do something. And in that case, depending on the terms of your contract and how you word it, you may or may not own some of the work product that they create. If you legally own it, it may still be something they prepared. They may be in possession of it, but you legally own it, and therefore it could still be a public record. The concept of possession also can get a little complicated. Usually, you think, okay, it's something I have, and that's pretty obvious. But keep in mind, when citizens send in their public comments or write you a letter from a constituent, that is something that's now in your possession. And if it meets the 3rd bullet point in the transaction of public business, it also becomes a public record, even though the citizen may have prepared it and they may actually have legal ownership of it. You have a copy in your possession in the transaction of public business. It is therefore a public record. The final note is just to say this definition does not say a word about drafts. So as a general rule, draft versions of records are subject to FOIA unless an exemption applies. I would note also, because we have a number of legislative members have the working papers and correspondence exemption, but I know that would allow them to withhold their drafts that are their working papers, but that's on the legislative side. Commission business is being treated differently, and you're wearing a different hat when you do commission business. So please keep that in mind. A few FOIA myths. These are things we've encountered over the years where people sometimes get it wrong. First is FOIA is about public records. It doesn't require you to answer questions, give interviews, or provide explanations. You can do those things if you want to. That's entirely your choice. FOIA doesn't govern it at all. FOIA does talk about information in a number of places, especially throughout the exemptions. There are legal structural reasons for that. Where you see information in FOIA, keep in mind it is a defined term and it means information contained in a public record. So if someone just comes up to you and says, hey, when is the next commission meeting? That's not really a request for a record. If they say, hey, can I have a copy of the commission schedule for the year? That is a request for a record. Also keep in mind the 3rd bullet point there, inspect or copy. It is the citizen's choice. They get to choose whether they just want to look at a record or whether they want to get a copy of it. Next one, it's not free. People think freedom of information, therefore it's free. We also hear a lot, well, we the citizens have already paid our tax dollars, and those tax dollars paid the people who created these records. So we've already paid for these records in the first place. Why should we have to pay again? Well, that's a policy call, but as of right now, FOIA does allow public bodies to charge for records. Next, difference between an exemption and a prohibition. Within FOIA, I counted up 148 different records exemptions and about, I think it's 54 meetings exemptions, all of which are optional. They are discretionary. They say that you may withhold a record or you may close a meeting, but you do not have to. You could also choose to release those records or to have the meeting openly. The difference between them and a prohibition, there's only 2 prohibitions in FOIA. There are a number of them outside of FOIA. Those say you shall not release. Sometimes they have limited situations where you can. Within FOIA, I'll use an example. If someone provides information about a crime and they're promised anonymity, you cannot release their identity. That is a prohibition. The other one is about student contact information. So I don't expect those to come up for this body too much. With the last one there, informal versus formal requests, there is no difference in FOIA. FOIA specifically says that a request does not have to mention FOIA in order for the rules to apply. So if you think about FOIA's rules as the default rules, that unless something else comes into play, such as, if you're getting a subpoena, you're under the rules of court. Whereas if you just get a citizen saying, hey, can I have a copy of that? Or can I take a look at that record? That would be FOIA. And they don't have to say FOIA. They don't have to cite the code. They don't have to do any of that formal stuff. There is no requirement for them to use a form. There's no requirement to sign a FOIA request. There's no formal requirements at all on the requester. So this is where we turn to how someone makes a request. First question, who has the right to make a request? The law says citizens of the Commonwealth and representatives of newspapers, magazines, radio, and TV with circulation or broadcasting in or into the Commonwealth have FOIA rights. However, I would note that's gone up to the U.S. Supreme Court, been challenged on constitutional grounds. It was upheld, but even the court noted that anybody can just go get a Virginia citizen to make the same request on their behalf. So if you do get a request from out of state, our general recommendation as FOIA Council policy is to go ahead and respond to them anyway. Because if you say no, they can just go to muckrock.com or one of the many other sites out there. They can hire an attorney. They can get their cousin, their college roommate, whoever it is they know in Virginia to just make the same request. I would note at the end there, we said, you don't strictly follow FOIA procedure when you're dealing with someone out of state directly. The reason being they actually don't have FOIA rights. So when you're dealing with them, it's really more of a matter of contract. We do encourage you to still generally follow FOIA just for internal consistency, if nothing else. But the usual complaint we hear is somebody says, oh, we want this big data dump of information that you have. And people say, oh, well, that's going to be expensive. And I'm concerned about trying to collect the money from them since they're out of state. Well, because you don't have to follow the FOIA procedure strictly, you can tell them we want the money up front and then we'll give you the records. And you can make a deal like that. Next, on how to request public records. There are very few requirements placed on citizens. The first one is to identify the records they want with reasonable specificity. All that really means is you can tell what they want. If you know what they're looking for, that's generally good enough as long as it's reasonably specific. I have heard of people saying things like, I want all of the communications to and from your office since you took office. That to me is not specific at all. I mean, you kind of know what they want, everything, but everything is not a specific request. That's a general request. Things the public body can do is you can require the requester to provide their name and legal address, and the law does say require. So if they refuse to provide it, technically they haven't made a proper request because you can require it. We already mentioned the request does not have to be in writing or say FOIA. Also, the requester's purpose does not matter. The Virginia Supreme Court looked at that in a case in 1988 where somebody asked for records for a commercial purpose, and they said nowhere in FOIA do we talk about purpose. It doesn't matter what they want to do with the records. What matters is do they have a right to them and whether the records are exempt or prohibited. Again, we reiterate here that the requester has the choice to inspect or to receive copies. When responding to a request, I always hold up my hand and remind everybody, if you have 5 fingers, you have a built-in FOIA cheat sheet that you can use because there are 5 responses to choose from and you have 5 working days to pick one. So once you receive the request, you have 5 working days after that. First day is the next working day, and note that weekends, legal holidays generally do not count. So typically on a normal week, when you just have Saturday, Sunday, you have 1 week from the day you got the request until you have to respond. That's typical. It can vary, things like Christmas, New Year's around then because of the different holidays. Also, different public bodies do different things. For example, Columbus Day, some public bodies are closed, some are open for business. So it can vary on that, but the general rule, about a week after. Failure to respond is deemed a denial and a violation of FOIA. So always make sure to respond to every request because you don't want somebody coming back later and saying, oh, you never responded, therefore you're in violation. Next, creation of new records not required. Sometimes somebody will ask you for something you simply don't have. You may have never created it. If you just don't have it and you don't create it, you don't have to create it. You may do so by agreement with the requester, and that's the last bullet point here. You are always allowed to come up with an agreement. Sometimes the default rules of FOIA will not work for a particular transaction, but it's something you can do, and so you can talk to the requester and work out a deal. When you do that, I recommend always discuss timing and discuss costs. These are the things where we see the most arguments is over how much it's going to cost and how long it's going to take. And if you can get it in writing, or at least memorialize it and send them an email or something saying, hey, we discussed this today and we agreed to da 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 da. You know, if this is not your understanding, please let me know. You know, just so you have something to refer back to. Technically, a FOIA request does not have to be in writing. An agreement does not have to be in writing, but it's good recourse in case something goes wrong later. With the 5 responses that we talked about, you got first, provide the records. That's the easiest. They ask for something, you give it to them, you're done. I would note for that response, you do not have to write a cover letter or anything like that. You just have to give them the records. If you do choose to write a cover letter and say, you asked for this and we are going to hereby provide you with X, Y, and Z in response to your request, that's fine. There's nothing wrong about that. But keep in mind, there's a consequence to that choice, which is you just created another public record when you wrote that cover letter, because every time you respond to a FOIA request, that is transaction of public business. I happen to know from the Library of Virginia, there is a 3-year retention period on records of FOIA requests. So if you choose to write that cover letter, you're supposed to keep it for 3 years. And this is where, again, we refer to the consequence of choice. There are many times you might be able to pick up the phone and have a conversation or talk to somebody face-to-face or over Zoom, or you have the choice of sending them an email, sending them a text message, talking in Zoom chat was mentioned earlier. When you do those things, you've created a record. Now, this is not a good, bad, moral type of choice. It is be aware of the consequence. If you create a public record, there may be a record retention schedule that you have to keep it for some period of time. And if someone comes in and asks for it under FOIA, unless there's an exemption, you'll have to produce it and give them a copy. So moving on to the other 4 responses, all 4 of these are in some way saying, no, you're not going to get the records. All of them are required to be in writing. The first one is where you're not going to give them anything. Second one, you're going to give them some of the records they asked for, but not all of it. With both of those, you have to cite whatever exemption or law allows you to withhold the records or prohibits you from releasing them when you do it. You have to identify the subject matter of what's being withheld. And if you're withholding things entirely, you also have to identify the volume. With number 4, this is where you don't have the records. That's all you have to tell them. If we can't find it or it does not exist, you know, something like someone asks you for the example of the census data that you don't have yet. Well, can I have the census data now? I'm sorry, we don't have it yet, so it doesn't exist yet. We can't give you that. Ask us again in, you know, August, September, whenever it is, you do have it, and it will become available. The last response, number 5, there is additional time. As we said, you always have 5 working days to respond. You can write to them, tell them why that you can't do it in 5 working days, and invoke up to an additional 7 working days. On the issue of timing, if 5 days plus those 7 for a total of 12 working days is not enough, the next step is to try to reach an agreement with the requester. And if you cannot reach an agreement, you can petition a court for more time. And at that point, it's up to the judge. A little bit about exemptions and redaction here. Again, exemptions are not prohibitions. They're not the same thing because the exemptions all have prefatory language saying the following records are exempt from mandatory disclosure, but the custodian may choose to disclose them in his discretion unless they're prohibited by some other law. When you're redacting things, you can only redact out the exempt portions. If you have a record that mixes things that are not exempt with things that are, you can pull the exempt portions, but you still have to release the things that are not exempt. So you can only withhold an entire record if everything in that record is exempt. On charges, I'm not going to go into super detail with charges. Most likely work with staff is my advice on this. If you need to charge for something, the basic rule is the public body may make reasonable charges that are not to exceed your actual cost incurred in accessing, duplicating, supplying, or searching for the requested records. Every word in that is important. The word may is you may charge, you don't have to charge. Again, that's discretionary. A lot of other versions of FOIA in other states and federal law may have waiver provisions where they specifically say under certain conditions you should waive the charges. We don't do that in Virginia. It just says may. So you may charge or not. That's up to you. You're always limited to the actual cost, and that word reasonable appears there. First year law school question, what is reasonable? For those who are not lawyers, the general idea is it's something that would be reasonable to an objective, prudent observer, given the facts of whatever the situation is. On a practical level, you're not going to really find out what's reasonable unless you end up in court and that the judge tells you, or a jury tells you, yes, this is or is not reasonable, because courts make the ruling on the facts. Always keep in mind, though, that first bullet point, you're limited to actual cost. You can never do more than whatever it costs the public body. The next two bullet points go together, and this is a fairly recent change in the law. We've always said requesters can get an estimate in advance, but we never had a provision before a year or so ago about them stopping the clock when they asked for the estimate. Now we do. Previously, we only stopped the clock if it was over $200 and the public body asked for an advance deposit. But now the way it works is if they ask for an estimate or it's over $200, you let them know, here's your estimate, that would stop the clock. Or if you sell them, it's over 200, we're going to require an advance deposit, that would stop the clock. Until they respond in the case of an estimate and they can say, okay, go ahead. Or if it's over 200, until they actually give you payment. Last, if you have billed them, so for example, if you have a bill that's $50 or $100 or anything under 200 and they did not ask for an estimate, then you would just send them the records and you send them a bill with it. And let's say that bill goes unpaid for 30 days or more. At that point, you do not have to respond to new requests from that requester until they pay the outstanding balance. Moving on, a few of the exemptions of general application, and these are things that you may or may not ever need to use for records, personnel records about individuals, attorney-client privilege, and legal memoranda or work products. So those are typically if you're involved in a legal matter, litigation of some kind, or simply communicating with your attorneys. Last, contract and procurement and account and routing numbers. For contract and procurement, the important things, all of them are similar, but it depends on whether it's a contract that actually falls under one of the procurement acts or not. If it does or does not, there are specific rules about trade secrets and proprietary records, and some of the timing is different. But the general rule for all of those is they protect records during the negotiation phase, but once a contract is awarded, most of the stuff becomes open. Last, account and routing numbers. This is specifically for any account and routing numbers on checks, credit cards, financial bank account statements, anything like that. But keep in mind, it's only for the account numbers and the routing numbers. So things like the actual account balances, a ledger of payments received, anything like that, those are open. Moving on to public meetings. Well, we can go back one second. We are note this. We're going to talk procedure for open, closed, and electronic meetings here a little bit. Again, general policy: meetings have to be open unless you've got an exemption that allows you to close them. We're going to talk about the definition of a public body and meeting a little bit. We're going to talk about the open meeting procedures, then the closed meeting, then finally electronic meetings. So first, definition of a public body. For our purposes, the commission is a public body. There's no doubt of that. The second bullet point gets a little more interesting. If you ever choose to create a committee, a subcommittee, or another entity, whatever you call it, so a task force or work group, anything, you can designate it how you like, but you give it a delegated function or tell it to advise you. So you create a study group, say, that goes out and studies, researches an issue, and then reports back to the full commission. That sub-entity is also a public body in its own right, and it is still subject to all the rules of FOIA. It also includes
we are at 11, so we have about 15 more minutes, and by my count, we have about 15 more slides, and this is the meat.
About 20, but we'll get there.
Okay, so that I want to try to wrap up by quarter after, so that we can have time for commission members to ask questions. Thank you.
We will, ma'am. Thank you. Yeah, and this is where these ones are not likely to come up. So I was going to skip this slide. And definition of meeting. The important parts, all meetings, including work sessions, if you're getting together physically or electronically as we are now, if you have as many as 3 members, or a quorum if less than 3. Quorum if less than 3 language will only come up if you create a committee, subcommittee, or some other entity that only has 2 or 3 members, because then a quorum would be 2. Otherwise, you have to have at least 3 members together talking public business in order for it to be a meeting. Note that that means 2 of you can communicate one-on-one if you want to, and it's not a meeting. However, keep in mind, if you do that, especially by something like email, text, social media, it's still a public record. All right. Last bullet point here, again, just like with public records, have to be about the transaction of public business. With meetings, there are exceptions if you are getting together for things that are not transacting public business. I'm trying to think if somebody was receiving an honorary award and some of the other members just wanted to go in the audience and say congratulations, but you're not actually discussing commission business. That would be a social event. That would not be a commission meeting. The exceptions here, gathering of employees. So keep in mind, all these rules apply to you as members, but they do not apply to us as staff. So Migo, Meg, and I are all DLS staff. We do not count towards your numbers for meetings purposes. As I said, if you're no part of the purpose is discussion or transaction of public business. And there's also an exception for public forums, candidate appearances, or debates. So this is things like when an elected member is running for re-election. If some of you wanted to attend in the audience again and listen to a debate, for example, you can do that as long as you're not discussing commission business. For open meeting requirements, you got to have notice. They have to be open to the public, and you have to have minutes. The notice requirements are date, time, and location of the meeting. And for state bodies, it's got to be in 4 locations normally. And keep in mind, this is for normal meetings. We're not talking the state of emergency COVID-19 stuff that we're doing at the moment. But the general rule is you have to post on your website, a prominent public location where notices are regularly posted, which for legislative entities is usually the Capitol or General Assembly building, currently Pocahontas building, but Pocahontas is closed, so we're not doing it. Again, Office of the Clerk or Chief Administrator, which is also generally in Pocahontas, GAB, or the Capitol. And then on a central, publicly available electronic calendar maintained by the Commonwealth, which for legislative bodies is the LIS calendar maintained by DLAS. For regular meetings, you have to post at least 3 working days in advance of the meeting, and you do not count the day of the meeting. For special emergency or continued meetings, the notice has to be reasonable under the circumstance, which again, it'll vary with circumstances and only a court can decide that for sure. And it has to be posted to the public at the same time the members are notified. Finally, if people sign up, and usually there's an email sign-up list and they want to receive direct notice, we send that to them as well. So usually what happens is people will post their notices, post it to the website, and send out an email notice to the distribution list. For the meeting to be open to the public, it literally means the public can be there, present. Currently, we're talking virtual presence for most meetings because of COVID-19 and the pandemic. Normally, you have to allow the public to record, photograph, or otherwise reproduce a meeting, and you are not allowed to meet in any place where they do not allow that. This is generally, you don't meet in courthouses that have security measures, other places like that, where they don't allow cameras or recording devices. Note that FOIA does not address things like room capacity. If you get back to having physical meetings with a quorum in one place, and we still have social distancing guidelines, for example, it may limit the number of people who can actually be in the room. And for that reason, we do encourage everybody to continue using live streaming, other forms of broadcasting, posting recordings, all of that, just to make the public more aware of what's going on. With meeting minutes, you only have to take them at open meetings, not at closed meetings. And you have to include date, time, and location, just like the notice, the members who are present and absent, and then the most important, a summary of matters discussed, deliberated, or decided. Now, normally, FOIA does not require you to have a full verbatim transcript or a recording of a meeting. If you have one, great, you can go ahead and put that up, but the requirement is just a summary for the minutes. They also have to include a record of votes taken, and if you have a closed meeting, you have to have a vote on a motion to enter the closed meeting and a certification afterwards. For agenda items, what all FOIA says is that if you have your proposed agenda and agenda packets, then unless the materials are exempt, you have to have a copy available for public inspection at the same time you make it available to the members. Note that we don't address agenda changes, parliamentary procedures, things like that, and the agenda is not required to be part of the notice. This is something that people get confused on sometimes, but notice only has to be date, time, location. It does not have to have the full agenda. If you have it available, great, but if you don't, then it's just whenever it's available to the members, have a copy for public inspection. With closed meetings, I don't know that you're going to have them. You might, so I'm going to go over it really quickly here. Basically, you have to have a motion to close the meeting. The motion has to have the subject, purpose, and citation to an exemption. When you read 2.23711 sub A, it starts by saying that the following purposes may be used for closed meetings. So when you quote or paraphrase from one of those exemptions and you cite it, that gives you number 2 and 3, the purpose and the citation. The number 1 is the hard part, where you have to get a little bit creative and say something more than what's in the exemption itself, because another part of FOIA says a general reference to the statutory exemptions is not enough, and the Supreme Court has upheld that. So you're going to have to say a little something more, but you don't want to be so specific that you defeat your reason for holding the closed meeting. So that's a chance for creative writing. When you're in the closed session, you're only allowed to discuss the items that were identified in the motion to close the meeting and are allowed to be discussed in closed meetings, so don't stray. As far as who can attend a closed meeting, you can always invite in people who are not members if they're going to help your discussion. And if you create something like a subcommittee and you have a member who is not on the subcommittee and that subcommittee is holding a closed meeting, the other members who are not on the subcommittee are allowed to attend the closed meeting, but not to participate. So they can just, watch and observe silently if they're in that closed meeting. When you certify, you're certifying afterwards that you only discuss things identified in the motion as were allowed to be discussed in closed meeting under FOIA. And I would note the General Assembly has added an extra penalty for improper certification of a closed meeting after hearing about a number of examples of such violations. On voting, it says all votes have to be taken at open meetings that are conducted in accordance with FOIA. I would note the Attorney General's office has a couple opinions out there. One where a meeting was improperly noticed, and they said any vote taken at such a meeting is void. We also have things saying that decisions in closed meetings are not effective until a vote is taken that reasonably identifies the substance during an open meeting. We also have an Attorney General's opinion saying that a vote taken where the substance was not reasonably identified, that vote was also void. So make sure you cross T's, dot I's, and follow the procedure when you're taking votes. Also, the no secret or written ballots part, no voting by email, by text, by anything like that, because those would be written ballots. I would note, especially for any senators in attendance, the Senate does allow written proxies, but that's because the Senate has constitutional authority to set its own rules of procedure. So that would be an exception from the usual FOIA rules. For this commission, no written ballots. Some of the commonly used exemptions that might come up, again, personnel, which roughly corresponds to the personnel exemption for records, actual or probable litigation or discussion of specific legal matters, again, corresponding to attorney-client privilege and work product. And there are ones for discussion of award of public contract, various other ones. So if you get into a contract or procurement situation, you'll probably be able to discuss that in a closed meeting. With electronic meetings, again, this is kind of a gloss over. We've got 6 processes currently. 5 of them are in FOIA. 1 is in the state budget language. 2 of those can be used by any public body. 1 is only for regional bodies. 1 is only for state bodies. And 2 are only during a state of emergency. Rough on this, I'm not going to get into the details of the procedure because they're all a little bit different. But a member can call in, and this is where you're having a normal meeting. A physically assembled quorum is present, but a member cannot attend due to a personal matter or a medical condition. Then they're allowed to call in on an individual basis. Both of those do require that there be a quorum in place. The body has a participation policy, and that the remote person's voice can be heard at the main location. Personal matters is currently limited to twice per calendar year. There was a bill passed that's presuming it goes into effect as of July 1. That will be 2 per calendar year, or 25% rounded up, whichever is greater. So we're waiting to see when that takes effect. When there's a state of emergency, currently there is 1 provision in FOIA that allows for meetings without a quorum, such as what we're doing right now, without a quorum being physically assembled. That one, however, is limited to addressing the state of emergency. So of course it wouldn't work for the pandemic because it's gone on for over a year now. So the other one is currently in the state budget, which allows for broader purposes, but it also has some additional procedural requirements. I would note that as of July 1st, assuming everything goes as passed the General Assembly and the governor doesn't make any changes, we have Senate Bill 1271, which is basically codifying most of the budget language into the existing FOIA emergency provision. and it'll allow for emergency meetings by electronic means without a quorum physically assembled when the governor declares a state of emergency or there's a local state of emergency. All of those can be used by any public body. And again, those are the ones and only conditions where you don't have to have a quorum. You also don't have to have a policy. Last, just notes, members can always just watch or listen to a meeting, even if you can't participate because you can't meet the procedural rules, you can still call and listen. Public and staff participation, like if you have a presenter, you can always do that electronically because public and staff is not subject to these rules. And for a state body, such as this one, you can hold electronic meetings where you have a quorum physically assembled for any purpose. You don't have to even state your specific purpose, but it's under another different set of procedural rules. So we do have an electronic meetings guide that goes into detail on that. And again, you can always call us. Last here, a note about FOIA and social media is because the definition of public records includes all these different types of records, social media can be a public record. Because social media allows people to communicate in real time in groups of 3 or more, it can also be a public meeting. So be careful how you use anything from, Twitter, Facebook, I don't know, Instagram, any of those things out there. But even other technologies are starting to open up these collaboration abilities, things like Google Sheets, where you can have multiple editors typing and communicating with each other in real time while working on a policy document, for example. You could end up having a meeting inadvertently if you have 3 or more members discussing things together in real time about commission business. So be careful with social media. Also, keep in mind what I said earlier about consequence of choice. Anything you put on social media that is commission business is going to be subject to FOIA as a public record at the very least. Okay, so what happens if something goes wrong? The basic rule is enforcement goes through the courts in a petition for mandamus or injunction where someone asks the court to order somebody to do something is mandamus, or not to do something is injunction. The petitioner gets to choose general district court or circuit court. Jurisdiction is for a state body, the city of Richmond, or wherever the aggrieved person resides. So it could be pretty much any court in the Commonwealth against a state body. And a single violation is enough to invoke remedies. With the petition, they're supposed to have an expedited hearing. The petitioner does have to notify the public body before filing. And this is the scary part usually, is if the petitioner substantially prevails on the merits, it says they shall be awarded their court costs, attorney's fees, and expert witness fees. And just as 2 quick examples, we saw a 1-page document argued over by a state agency where the other side had hired a named partner in a firm, cost the state agency $30,000 when they had to turn over a single piece of paper. We saw a case that went from general district court to circuit court to the Virginia Supreme Court on meetings issues. This is 15 years ago now, that ended up costing a locality $93,000 in attorney's fees. So these things can get very expensive. Last bit here, keep in mind if you've used an exemption to withhold records or close a meeting, then you as the public body will bear the burden to prove that that exemption applies. There are also extra penalties for willful and knowing violations, specifically up to $500 to $2,000 for a first violation, $2,000 to $5,000 for the violations that they prove you knew what you were supposed to do and intentionally did not do it, you did something else. And that would be paid out of pocket, not by the public body, to the literary fund. You can introduce opinions of the council as evidence that it was not knowing and willful. Finally, there are additional penalties for the improper alteration or destruction of public records with the intent to avoid FOIA, and that's a penalty up to $100 per record, again, paid by the individual to the literary fund. And the note at the bottom, retention periods are set by the Library of Virginia, so if you're not sure of a retention period, check with the library. And last, as I mentioned before, the extra penalty for improper certification of closed meetings, up to $1,000, paid this time by the public body, not by the individual, to the literary fund, and it allows the consideration of mitigating factors of opinions from the Attorney General, court cases, and advisory opinions from the FOIA Council. And that concludes the presentation at 11:15.
Alan, you did a great job. Thank you very much. That was a lot of information. And for those who aren't familiar with FOIA, it can be a little bit overwhelming. A couple of statements and then we'll open it up for questions. One, we will be sharing this presentation with all commission members with all of the hyperlinks, so you can take your time to go through that. Two, for especially the citizen commission members, we're going to be leaning heavily on the DLS staff to really guide us and keep us within the guardrails of Foia, so that we can have some comfort in that. We would encourage all commission members to use their special commission email to be able to protect your private information from commission business. In general, I would say when you get emails related to the commission, do not hit reply all. And if you reply to generally Claire Waters, she can get information out to others if you have suggestions and things of that nature. Every meeting of the commission is open to the public. It is recorded, and the public will have a comment period. And we want to have that as part of the intent of Foia laws, to be able to be transparent and accountable to citizens of Virginia. And the last thing, I think Mackenzie and I have gotten lots of inquiries on our commission emails from a wide variety of citizens who are interested in our shared work. And Mackenzie and I have worked with the staff to be able to draft a correspondence, because up until this point, we have not responded. And so we will share the draft correspondence that you can use as well for inquiries that are coming to you as individuals, to be able to respond appropriately and to recommend different strategies for citizens to engage with us, because honestly, we can't engage with them outside of these types of meetings about the work of the commission. So with that, we'll open it up for clarifying questions that members may have about the rules of Foia. Anyone?
I have a quick question, just since this is, Madam Chair, since this is so different from the past, right, 10 years ago when this was all done in the legislature, how starkly, you know, I think we understand how these rules all apply to citizens. I'm wondering, the same rules for this body apply to the elected members of the body, whereas if another member of the General Assembly or the Senate was to ask one of the elected officials on this body about the work of the commission or a specific district, I'm guessing that would not be allowed to be discussed.
Alan?
May have to pass this one to Amigo a little bit, but I will read to you. I am looking at 30-392 sub F and sub G, which are not part of Foia. This is part of the commission's enabling legislation. Sub F is the part I read. Part of it before says all meetings and records of the commission shall be subject to the Virginia Freedom of Information Act, except as provided in sub E of 30-394. All records and documents of the commission or any individual or group performing delegated functions or advising the commission related to the commission's work, including internal communications and communications from outside parties, shall be considered public information. Sub G says commissioners, staff of the commission, and any other advisor or consultant to the commission shall not communicate with any person outside the commission about matters related to reapportionment or redistricting outside of a public meeting or hearing. Written public comments submitted to the commission, staff of the commission, or any other advisor or consultant to the commission shall not be in violation of this subsection. So you're going to have to follow within those rules, and generally everything is subject to Foia. But beyond that, I don't know that I can give you a specific interpretation, because that actually is not part of Foia.
Madam Chair and Mr. Kumar, yes, the elected representatives that are on the commission are commissioners, and there's no exemption or language that would exempt any of the contacts. So for the purposes of the work of the commission, when the senators and the delegates are performing commission work, they are commissioners. I know that's a sort of a different situation, but it does apply to the elected representatives of the commission also.
Thank you, Amigo. other questions that members may have?
Madam Chair, James Abrinio here.
Yes, James.
And I'm not sure if this applies to FOIA, if this is the right request, but you know, us citizen members trying to wrap our heads around information. We've received a pamphlet from Princeton Gerrymandering Project, which Citizens Guide to Redistricting. There's a lot of information out there, presentations, which, you know, have been very useful. I'm wondering if it is okay for us as commissioners to attend, you know, map drawing presentations and things like that, just so we're not feeling kind of behind the ball as far as never having dealt with this technical area of law.
Amigo, would you like to respond to that, please?
I mean, if the attendance is just as an attendee where you're involved with the map drawing lab, you know, I think that would be fine. I guess the issue would be if you got there and you wound up seeing 4 other members or 8 other members, you know, if you're not there, you know, for the purpose of doing commission business and you're not discussing the work of the commission, you know, I think that you will be fine. And Alan, am I right about the what they used to call the bump into provision?
Mm-hmm. Yeah, and this is something we see a lot with other elected and appointed officials too. As you may have a workshop or a training presentation or something, you go to it and you happen to see other people who serve on the same body. You know each other, so you say, "Hey, let's sit together." Well, that's okay as long as you're just receiving information in the training or the workshop and you don't start discussing your commission business. But as Amigos noted there, it's if 3 or more of you do discuss commission business, it becomes a commission meeting. And you'll note in that definition of meetings, it doesn't matter where it occurs, whether it's formal or informal, and it says sitting as a body or informal assemblage even. So if you happen to run into each other, you bump into each other, or a chance meeting, as we call it, that can turn into a meeting, but only if you're discussing commission business. As long as you stay off that topic, it's not a meeting.
Madam Chair, if I could jump in to build off of what Alan and Amigo both said, you know, I think they did a good job of addressing the FOIA part of that question that Mr. Abrinio asked. But as far as the language in our in the code section related to the commission and who staff and commissioners can discuss things with, I think if you attend a training, you know, put on some by some group, you're going to be fine. I would just be cautious to not necessarily identify yourself or the reason that you're there as commission work. Certainly you're, you know, trying to get that experience, but making sure that you toe that line about how freely you discuss what the commission does or what the commission is working on at the time.
Okay, thank you. So as long as I sit down and keep my mouth shut, I should be good. Thank you so much. I appreciate it.
And Alan, can we just get clarity so that if an email comes out from the DLS staff and we do hit reply all, is that considered a meeting if we're within the body of the email, it's talking about our schedule or something else related to the commission, and it's going back to all commissioners?
It's, Madam Chair, it's going to go into a deeper factual determination, and only a court can actually rule on it for sure. But what I can tell you is issues of email as a meeting have gone to the Virginia Supreme Court twice. In 2004 in Beck versus Shelton, and then again about, I think it was 2012, Fairfax School Board had a case, Hill versus Fairfax School Board, if I remember right, where in Beck versus Shelton, they did have emails going between 3 or more members, but they were delayed in time so that any email sent out and any response sent back had, I believe it was a 4 or 4.5 hour delay. And this is where the court said that term assemblage means you have to be discussing things in real time. And because of the delay, those emails did not amount to a meeting because of the delay in time. In the Hill case, the plaintiffs actually came to one of our seminars and showed us one of their exhibits where emails were going back and forth 1.5 minutes apart. However, in that case, all the emails were one-on-one. They said between, you know, just 2 members at a time total, not 3. And they said only 1 was sent out to 3 or more members, and that was a straight distribution, and it had no replies. So technically, yes, you can communicate one-on-one or in a distribution that has a delay in time, but to be safe, this is why we tell you don't hit reply to all. And if you can, send things to staff. I believe Claire would be handling these, and have Claire, if you want to distribute something to all the members, have her do it, and she can put the group list on the BCC line. And that way, if somebody does hit reply to all, it still only goes back to Claire, and then she can redistribute with a delay in time. And that's serves two purposes, really. One, it prevents you from having a meeting inadvertently where you didn't mean to. And number two, it also would allow Claire to have a copy of all those emails. And that way, if a request comes in, you can go to Claire and she can pull it up. If, on the other hand, and this is something we've seen before, where members of a body start using their personal accounts or work account, their home computer, their laptop, whatever, all these different things for their public business, we have seen situations where it's gone to court, and then you're under the rules of court, discovery, and evidentiary rules, and they might make you ghost all your hard drives and give me a copy of your home computer and everything on it, or your work computer. And obviously those can be problematic. So again, as you said, encourage all the members to use their government accounts and keep stuff on there and not use other accounts. If you do have something, say a friend emails you about commission business and they happen to use your personal account, forward that over to your government account, CC it, make sure you do that as a strict rule, and then everything will be on the government account, and you can make sure you're not having an improper meeting and you are following the records rules.
Thank you, Alan. There was a comment in the chat around, does Foia impact the chat feature when we're having digital meetings?
It can. I'm not going to tell you not to use it, but it's something that, as someone pointed out here, they expect the chat to be part of the record. And that's a good policy. Make it part of the record so people can see what you're doing. The concern is with something like a chat feature, you could inadvertently end up having a meeting within a meeting that is not made public. And that potentially, we have seen it factually in a number of different iterations where it did not amount to an improper closed meeting. But that's the concern is, does somebody then end up having a closed meeting where the members are actually secretly discussing something in the chat that the public can't see? And so you don't want that to happen. So I would be careful not to do that. And again, keep in mind, anything you put in chat is a public record.
Madam Chair, clarifying question on that.
Yes, Sean.
Mr. Gernhardt, so if the chat, if we're doing it on this platform, and if the chat is made available so the public who's dialed in can see it and it's added, then is that, publication for the meeting sufficient?
Yeah, I think, let's see. I'm just looking in the chat. Yeah, you can put in all panelists and attendees to send the chat to. So if you send it to everyone and everyone who's there can see it, I don't see a problem with that. It's, like putting it up on a big board and everybody can see it then.
Yeah.
The only,
I know it's something we may need to discuss whether we want to use or not. It's just given, it is one of the few advantages of not meeting in person, especially with 16 people plus staff. And it's just something that I guess we'll have to take up at some point to discuss if we want to utilize that or not, if the benefits outweigh the potential negatives.
Right. I would also note, I believe you have a member here who's on the phone, and that member probably can't see the chat. So that's something else to just keep in mind.
Okay, so we'll keep a record of that and come back at one of our future meetings to just get clarity around what the commission wants to do around the use of chat. We have about a minute left before we're going to transition to the public comment period. Are there other burning questions for Alan while we still have him? This is a brilliant group. They got everything that you said, Alan. That's fantastic. I think, again, I feel comforted by knowing the DLS staff knows FOIA regulatory frameworks very well, and I think will provide a lot of guidance for us as we continue to do our work this year. Alan, thank you so much for sharing that, and I'm sure we may have future questions for you. Thank you.
Thank you, Madam Chair.
Okay, so following our agenda, we are now going to move into our public comment period, which we will have at every commission meeting. We want to encourage Virginia citizens to participate and help educate commission members around their concerns and ideas around our redistricting process. In order for citizens to participate, they have to register up until 24 hours before one of our scheduled meetings. And we have 18 citizens who have followed those guidelines, and we have about 30 minutes left in our meeting. We will try to get through as many citizen comments as possible. We're going to ask each citizen to limit their comments to 2 minutes, and we just appreciate their interest and in their participation with the commission. I believe that Shay Capers, who is another DLS staff person who I unfortunately forgot to introduce as well. Shay is one of the team members who will be assisting us. She will let people in and also monitor the 2-minute timeline. So with that, I will begin to call those individuals who have pre-registered. And I apologize beforehand if I mispronounce your name. It is not with any ill will. Our first citizen comment individual will be Ankit Jain or John. Good morning. There we go. Hi, how are you? Welcome.
Can you hear me?
Yes.
Okay, great. Thank you. So my name is Ankit Jain. I was a volunteer with One Virginia in trying to get this amendment passed. And I'm from Vienna, Virginia, Northern Virginia. And my comment is to the citizen members of the commission. I don't want to be too negative, but I just want to make sure you all are aware about the responsibilities you all have here. I don't think you should assume good faith from the politician members, because we do have members of this commission who are politicians who participated in gerrymandering of the state, who worked to stop the amendment that would create this commission so that they could then gerrymander the state for their benefit. And y'all represent every Virginian who just wants fair maps, who wants to be choosing their politicians and not the other way around. And it's a big responsibility you have. So I hope you're willing to speak up and not just assume that the politicians know the best because they've been doing this for a while, and to be willing to speak out if they're trying to push you towards an incumbent protection gerrymander, because I think that is a risk that we're facing here. And the last meeting, I was a little concerned with kind of what some of the politician members were saying. So I hope that y'all are willing to stand up and stand out and speak for all of us Virginians who just want fair maps, and make sure that we have truly fair maps and not some sort of bipartisan incumbent protection gerrymander. So I want to thank you all citizen members for everything you're doing, and I hope you use your voice to speak out for all of us. Thank you.
Thank you, Mr. Jain. We appreciate your comments. Our next participant is Ken Chasen.
Madam Chair, if I could just get some clarity. I know that it seems that we're allowed to respond to the public. Are we going to do that all at the end or per speaker?
I was thinking, because we have so many individuals who are seeking to speak, that we would be in a listening mode right now, James.
Thank you.
Okay, is Mr. Chasen on the line? Mr. Chasen, if you could unmute yourself, please.
Can you hear me now?
Yes, thank you.
All right. My name's Ken Chasen, and I live in Charlottesville, Virginia, and I'm a retired information technology professional whose areas of expertise include business intelligence and business intelligence solutions and data analysis. I have developed a redistricting strategy proposal for Virginia's congressional districts, which I emailed to the commission last week. And the proposal lays out 7 criteria for drawing Virginia's new congressional district maps and are in agreement with the criteria set forth by the Virginia Redistricting Commission, U.S. Supreme Court rulings concerning redistricting, gerrymandering, and criteria used by other states for redistricting. And the criteria very briefly are: 1, incorporate the concept of communities of interest and communities of place. 2, ensure that the congressional district land areas be contiguous and be of equal population as much as possible. 3, allow for racial fairness. 4, don't give a partisan edge. 5, preserve existing geographic boundaries of city, town, and counties. 6, reflect U.S. Census data as concerns the number of congressional districts allocated to Virginia. And 7, the land area chosen for each new congressional district map should be reflective of key demographics. The other point I like to make to you is I've been collecting demographic data pertaining to Virginia's existing 11 congressional districts and its 25 most populated counties, which I've organized into a set of Microsoft Excel dashboards and charts. And I emailed samples of the dashboards and charts to the commission last week. And I'd be glad to share more of the demographic data with the commission. And I was using the U.S. Census American Communities Surveys 2019 5-year estimates.
Thank you so much, Mr. Chasen. We appreciate your comments.
Thank you.
Our next speaker is Philip Thompson. Mr. Thompson?
Sorry about that. I had a little technical difficulty. My name is Philip Thompson. I am the president of the executive director of the National Black Nonpartisan Redistricting Organization. And we've been heavy in this fight for the last year and a half on getting the redistricting bill passed, both in the House of Delegates, and I mean the General Assembly, and also the election. Our primary concern with redistricting deals with minority communities. One of our key concerns, we know that the African American community is well represented on this body. They're also well represented, by people participating. We're also concerned with other minority communities such as Asian and the Hispanic community. And we would hope that at some point this redistricting commission would have some sort of way.
Excuse me, Mr. Thompson, can we please mute everyone? Please mute your phones, please. I'm sorry, Mr. Thompson, please. Continue.
No problem. No problem. I was hearing the same thing. I think it's important that this commission also think about doing some of their work in Spanish, so as to make sure that their information is being sent out to the Hispanic community in a manner that is communicable to a lot of their citizens, so they understand their rights. Our organization intends to do a event in Spanish, and we hope that some of the commissioners, yourself maybe, can participate in this event. We want to be sure that the districts in Virginia are aligned to represent all the communities and all the people in Virginia, and we'll continue to work with you. We'll have comments coming in, and we're out there. If anything we can do to assist the commission, we look forward to it, and we thank you for your efforts.
Thank you so much for your comments, Mr. Thompson. We appreciate them. Our next speaker is Lois Maiden McCrae.
Hi, thank you for allowing me to participate in the meeting. I work for Philip Thompson, so I ditto everything that he had said. So we're really looking for the commission to ensure that we make sure we do what's best for Virginians. And I agree with that first guy that said we don't want to assume that political folks agree with what's going on. We want to just make sure our voices are heard and that we are represented in a fair way, and to make sure change continues to happen. So that's the biggest thing. We want to make sure change continues to happen in a positive way for the Black and Brown voters.
Thank you, Ms. Maiden-McCrae. We appreciate your comments. Thank you.
Yes, ma'am. Yes, ma'am.
Our next speaker is Jane Leopold. Jane Leopold.
Madam Chair, they're not here.
Okay, thank you very much, Shay. Our next speaker is Jeff South. Mr. South?
Hi, I am the president of the Virginia Coalition for Open Government, as well as the president of the Virginia Pro Chapter of the Society of Professional Journalists. And speaking especially on behalf of VCOG, I would like to respectfully ask the Virginia Redistricting Commission to conduct its business in public to the greatest extent possible, and to consider not just the letter, but also the spirit of the Freedom of Information Act. There's public relations value in how the commission conducts meetings and responds to requests for records. The more open you are, the greater the public trust and the buy-in to what you're trying to accomplish. We realize that there are exemptions to FOIA, circumstances in which a governmental body can meet in private or withhold records, but those exemptions are discretionary and they don't have to be used. Moreover, if the commission does decide to meet in closed session or to deny a request for documents, it's crucial to explain why, because the public values context. Thank you.
Thank you, Mr. South. We appreciate your comments. Our next speaker is Liz White.
Good morning. Thank you for the opportunity to speak to you all today. My name is Liz White. I'm the Executive Director of One Virginia 2021, a nonpartisan organization dedicated to the fair and representative redistricting reform in Virginia, and one of the many groups in the state who's spent years advocating for improvements to our former redistricting process. On behalf of our volunteers and our supporters across the state, our organization is very proud of the steps Virginia has taken toward an entirely new system of drawing legislative maps, the heart of which is this group meeting here today. Your role is historic. We are thankful for your service, and we have very high hopes for your work and for its results. We believe that the most important parts of the redistricting reforms that have passed in the last 2 years are those that elevate the role of the citizenry. The Commonwealth's legislative districts belong to Virginians, not to any political party or individual politician. And above all else, we think that the requirements that the commission require public input, consider communities of interest, and open all proceedings to the sunlight of democracy or of transparency, those are the truly historic aspects of this new process. Having reviewed the information you all put out, we're heartened to see that you'll be using these extra months provided by the census delay to prepare yourselves for this task. And as you finalize that timeline, we hope the commission will dedicate additional time and resources to thoroughly enabling public communication and to determining how best to receive and incorporate feedback from the diverse communities across Virginia. One Virginia and several other organizations have signed on to an open letter, which we have sent to you all earlier today, and which you can find in your inbox and on our website. with a list of questions that we hope that you will ask yourselves as you make your more detailed plans going forward. We appreciate your time and thank you for this opportunity to speak to you today.
Thank you, Ms. White. We appreciate your comments. Our next speaker is Patricia Harper Tunnley.
Hello, can you hear me?
Yes, Ms. Harper Tunnley, we can hear you.
Thank you, Madam Chair, and to all of the members on the committee. My name is Patricia Harper Tunnley, and I'm from Lunenburg County, Virginia, which is a small rural area. And my comment at this time, first, thank you for the opportunity to listen in on how you plan to move forward. And I would like to state that I hope and trust that we're working towards diversity and transparency, as well as allowing the citizens to select their candidates for representation. But I also hope that the commission will also reach out to the localities and get some needed feedback from those localities, especially in the rural areas, to help with diversity and ensuring that all citizens are included in this process. So I would like to thank you for the large job that you have at hand. I would like to thank you in advance for doing your best, because Virginia is the best and we're going to be making the mark for others to follow. So I have high hopes for this group and for our Commonwealth. And please let me know if there's anything I can do to assist. I would like to be very involved.
Thank you, Ms. Harper Tunnley.
In the process and follow with how we come about change.
Thank you so much for your comments. We appreciate them very much. Our next speaker is Chris Mitchell.
Madam Chair, he's not here.
Okay, thank you very much, Shay. Our next speaker is David Poirier.
No, ma'am.
Not here. Okay. Our next speaker is Fran Larkins. Ms. Larkins, if you could take yourself off mute.
Okay.
Yes, we can hear you.
Okay, great. My name is Fran Larkins. I'm a resident of Fredericksburg, and I've been actively involved for several years in redistricting reform in Virginia. As commissioners, you have a difficult job ahead in creating and evaluating redistricting plans for our state. I understand that Citygate mapped drawing software will be used. I hope you will also be calling on outside redistricting experts. I'm familiar with the metric, geometry, and gerrymandering group at Tufts University. Moon Duchin, who leads the group, is a highly respected mathematician who has provided nonpartisan assistance to redistricting commissions across the country. Her group can help in assessing whether redistricting plans adhere to the principles of state and federal law. Her analytical skills could prove essential to the success of Virginia's redistricting efforts. I hope you will consider her for assistance, and I thank you all so much for everything you're doing. Thank you.
Thank you so much for your comments. We appreciate them. Our next speaker is Christine DeRosa.
Not here, Madam Chair.
Okay, thank you so much. Our next speaker is Erin Corbett.
Hi there, can you hear me okay?
We can, thank you.
Thank you so much, Madam Speaker, and thank you so much for the Commission for letting us speak today. My name is Erin Corbett, and I am the Redistricting Coordinator from the Virginia Civic Engagement Table. And in this role, I've collected feedback from grassroots organizations, from citizens that I would like to provide today, which reads, we recommend several measures for the Commission to foster an environment where all Virginians are encouraged to participate, ask questions, and be represented in the redistricting process. This includes creating and maintaining a website available in all languages representative of the Commonwealth, not just English, to schedule meetings and hearings during times in which Virginians can reasonably be expected to attend and make that schedule publicly available as soon as possible, to advertise via both media outlets and social media every meeting and hearing, to warehouse recordings and transcripts of meetings on the DLS website, to ensure that public comment is accessible and encouraged, and that this public comment is cataloged and made publicly available and accessible, to make all work product publicly available and as soon as to the extent practicable, and to conduct active outreach to diverse communities and interest and intentionally involve their input into your processes. Thank you so much for your time.
Thank you, Ms. Corbett. We appreciate your comments. Our next speaker is Bill Millhauser. Mr. Millhauser, you're on mute. There we go.
I'm coming. You have the video? Do you have my video?
Yes.
Okay, great. Hi, thank you for the opportunity to speak today. My name is Bill Millhauser. I'm a resident of Falls Church. I'm also speaking on behalf of Candace Butler of Annandale, Joanne Kennedy Flanagan of Fairfax, Janet and Michael Martin of Springfield, Kathy Utgoff of Falls Church, Deborah Mayer of Centerville, and Pat Casano of Alexandria. I would like to very briefly summarize the key points of our March 23rd letter to the Commission regarding the need for a comprehensive and up-to-date website for the Redistricting Commission. The Commission and DLS are directed by the Code of Virginia to develop a website to facilitate public participation in the work of the Commission. We understand that many of the work tasks of the Commission are just now getting underway, and we urge that the Commission make the completion of the website a top priority. The website is an essential component of the transparency requirements of the amendment and be one of the main methods of communication between citizens and the Commission. The website must be comprehensive, up-to-date, intuitive, and easy to use by all citizens. Most importantly, the website must clearly describe the various ways that the citizens can participate in the process. In our March 23rd letter, we had included a summary of our survey of the Redistricting Commission websites for 5 states: Arizona, California, Colorado, Michigan, and Washington. We reviewed these websites looking determine the extent to which they provided 12 categories of information, examples of which include all legal requirements for map drawing and approval and commission procedures, plan implementation goals and objectives and timeline of major events, milestones and deadlines, commission meeting schedule far in advance so citizens can make plans to participate, and a description of how citizens can participate in the process, including procedures whereby citizens can provide comments. Based on our review, we believe that Virginia has much work to do to complete the development of up-to-date redistricting website comparable to those found in these 5 states and which meet the needs of the citizens of the Commonwealth and fulfill the legal requirements for the Commission. We urge—
Your time is up, sir.
Okay, we urge the Commission to initially begin implementation of an updated website within 30 days and complete development within the next 2 months. Thank you.
Thank you, Mr. Millhauser. We appreciate your comments.
You're welcome.
Our next speaker is Perry Darley.
Thank you, Madam Chair and members of the commission. As a applicant who was not selected, I look forward to seeing the work that you and the commission are doing. I also echo the first gentleman's concern about political gerrymandering, which is one of the reasons I was interested in joining the commission. This is a very important task that the commission has in front of them, and I look forward to their work results. I just want to thank you guys for taking the time to do this and the people who fought to have this commission joined so we can have citizen involvement. I just want to make sure that there's ample opportunity in the future as these meetings go on, that we, the citizens, have a chance to respond to your work products that you put out and have a chance to provide our input as the maps are being drawn, so that we don't come up at the end and just yes or no, but we do have input throughout the process. Thank you.
Thank you, Mr. Darley. We appreciate your comments today. Our next speaker is Ray Pickett.
Not here, Madam Chair.
Okay, thank you. We have two more speakers, Michael Angeloni.
Not here, Madam Chair.
Okay, and last but not least, James Turpin. Mr. Turpin, you're on mute. Mr. Turpin, we can't hear you. Shay, is there a way that we can unmute him? Shay, is there a way that we can unmute Mr. Turpin?
Yes, ma'am. I've just asked him to unmute. Try again.
Okay. We're so close here. Amigo, any suggestions as to what we can do here? Oh, hold on, he's connecting another way. Here we go. Mr. Turpin?
I didn't sign up to speak.
Okay. All right. Well, thank you for letting us know that. All right. All right. Well, I believe that we have gotten through our agenda, and I just want to thank all of the commission members and all of the citizens who gave comment. This is an exciting and really important body of work that we will be doing together in 2021. I can commit that after speaking with many of the commission members, we are committed to transparency, accountability, inclusivity, and integrity to represent all citizens of the great Commonwealth of Virginia. We do want to be an exemplar for the country and the body of work that we will do together.
Excuse me, Madam Chair.
Yes.
I'm sorry. Chris DeRosa was in the Zoom room, but he said he was using the link from Frank Larkins. He would still like to speak.
Certainly. If people will just hold on for 2 minutes more and our last comment, and then we will end the meeting. And Shay, who was it again that was coming on?
Chris DeRosa.
Okay.
You should see Frank Larkins.
Okay. Okay, there we go.
Hi, I'm
Fran
sorry.
Larkins.
I had lost my link and I used Fran's link, so I think I was under her name. Hi, everyone. I'm Chris DeRosa. I'm from the Arlington area. Like many Virginians, I've been waiting anxiously for the second meeting. And I congratulate all of you and ask that all of you, especially Ms. Babichenko, Ms. Harris, and the other 6 citizen members, to be the voice of the people of Virginia as you undertake this important task. 2 of the things that are of greatest importance to me are, number 1, transparency. Virginians deserve a voice in this process. Open meetings and documents are critical. You must publicize widely your meetings and share all documents, including emailed comments and questions. Other media outlets, not just the DLS website, should be used to notify the public of key events. After listening this morning, I have, this is even more important than before. So I'm concerned that we have widely publicized the dates that you have provided to us, but now those apparently are going to be changed. So people need to know that. I think the idea of a distribution list would be very important so that we don't have to constantly check the DLS website to see if something new has been added, as you have done in the last 12 hours, which I see you've updated the criteria, for example, which was very much needed. Also mentioned earlier today, I think there probably has been chat among the commission members, which we cannot see. And again, that some of that discussion should be provided to the public. Number 2, citizen input is critical. The voters of Virginia want to be heard. Among the criteria for maps is respecting communities of interest. You'll be hearing from many of us about our communities of interest. I hope that you have availed yourself of the many resources available, including redistricting guides and recorded webinars that can inform you as you draw the maps. So thank you for allowing me to speak, and good luck as your mission continues.
Thank you, Ms. DeRosa. We appreciate your comments. And with that, commission members, I believe that we have concluded our work for today, and we continue to wish everyone well and safety until we meet again. Thank you so much. Have a great day.
Thank you.